Hello, my name is Brian, and I'm one of the attorneys here at Fidelity Law. My clients often come into my office and ask me about obtaining debt forgiveness. This term, debt forgiveness, has become very popular lately as certain law firms or other debt companies have attempted to package and market their services in the most positive light for consumers. And the term forgiveness has such a nice feel to it. Like your creditors will suddenly decide to void all of your debts in an effort to grant you absolution for your past spending. Well, debt forgiveness is possible, but let me break it down for you a little bit. Debts don't usually just go away. Your creditors are in the business of collecting debts from you, not forgiving them. So to actually eliminate your debts, you need to use force. Playing Mr. Nice Guy with your creditors just won't do it. One way to eliminate your debts is through the use of state law. Each state has different laws, but generally there are a series of consumer protection laws which can be used to prevent your creditors from collecting from you. These laws include such things as the statute of limitations or certain fair debt collection laws. In certain cases, with the use of these laws, you can force your creditors to forgive your debt. They certainly won't do this willingly, but if you have the law on your side, then they really don't have a choice. Another way that you can have your debt forgiven is through the use of federal law. Specifically, the Federal Bankruptcy Code allows the discharge of all of your unsecured debts through the use of a Chapter 7 bankruptcy. A discharge basically protects a debtor who receives it from any further personal collection liability in connection with unsecured debts. It's important to know that this form of forgiveness only applies to the debtor who receives the discharge. It doesn't really make the debt evaporate, but rather prevents the creditor from collecting from the person who filed the bankruptcy and ultimately received the discharge. This becomes important in many cases, particularly if there are several parties who have co-signed on the debt, or in the event that we're talking about a married couple in which only one of the couple is filing for bankruptcy. It's also important to know that a bankruptcy discharge only prevents a creditor from attempting to enforce personal liability in connection with the debt. So this is really personal debt forgiveness. This means that other types of liability usually stay intact. So in connection with secured debts, like mortgages or car loans, even though the personal collection liability may be forgiven, the underlying rights to the property will remain intact. As such, a creditor may no longer be able to collect from you personally, but they certainly can still take back the property which was used to secure the debt in the first place. So let's take an example. Let's say you lend me money and you take a lien against my car as a security interest for the loan. And then I were to file bankruptcy and receive a bankruptcy discharge. Well, this does not make the debt just go away. Instead, what occurs is that the discharge erases my personal liability for the debt, but it doesn't impact your security interest in the car. As such, you could still repossess my car in order to satisfy the debt. So, when you hear companies or law firms advertising that they can secure debt forgiveness for you, just make absolutely sure that you pin them down to exactly what they're talking about. You may be surprised at what they're calling debt forgiveness. Good luck, and have a great day.